All right, Freedom of Information Act. This is the 800-pound gorilla that can get you so much information. That stipulated order that had all those lines drawn through it, guess what? There was a Freedom of Information Act that looked just like it that was attached, and it wasn't signed by yours truly, it was signed by my client. This is what I get in response from most police departments, not all. They start to cry. This is going to interfere with law enforcement proceedings. It's going to constitute an unwarranted invasion of privacy. This will disclose law enforcement investigative techniques, disclose operational instructions for law enforcement officers, reveal the contents of staff manuals, and this down here at the bottom one is my favorite one. This will circumvent the discovery process. Oh, by the way, there's no discovery in misdemeanor cases, they'll quickly say. City of Riverview right now has denied me access and my client access to all materials, saying that FOIA, you can't use FOIA because it circumvents discovery. You can't get discovery because there's no discovery in misdemeanor cases. So we were before the judge the other day on a Brady motion. I said, Judge, you have to dismiss this case. He said, why? I said, because I haven't even seen the data master ticket. Huh. So, when they deny you under FOIA, though, this is a great opportunity for a little cottage industry, because you're not the person requesting this information, your client is. And when they deny your client the opportunity to review public documents, you sue the bastards. The cities and police departments have an affirmative duty under FOIA to separate exempt materials from that which is non-exempt. This is Evening News Association versus Troy, a 1983 case. And that law remains unchanged to this day. Now there's lots of little nuances and all that that are out there as to what you're allowed access to. But generally speaking, a person who's not incarcerated is entitled to full disclosure of public documents unless it's specifically exempt under the statute. Read that statute. And then when you have to sue a local jurisdiction because they're not giving you access to these materials, the statute says that your client, who's the person suing, is entitled to $500 in punitive damages, reimbursement of costs, and reasonable attorney fees. It's only a matter of time before these police departments start paying off defense attorneys with their plaintiffs' lawsuits and FOIA actions before they finally realize that maybe we ought to just cooperate with the defense and give them access to public documents. All right, filing motions to win DUI cases. Stop and seizure motions, the arrest decision, and chemical testing. When you file these motions, I can't tell you how many times I've looked at the judge and the judge says, Mr. Mays, it's your motion, you may proceed. All right, I'll call the officer. Or what if there's no witnesses? Whose burden of proof is it? In all reality, once you allege that a person was stopped and arrested without a warrant, you've already met your burden at that point. Now the entire burden shifts over to the prosecution. It's their job to explain why there is some exception to the warrant requirement that justifies the stop and the arrest. And then when it comes to breath testing, whose burden is it there? You file a motion saying, hey, they didn't follow the proper procedures, they didn't observe for 15 minutes. You might not even get that specific. Just say they didn't do it right.